We don't have to send it, do we?
Andy? Andy? Nothing?
Test, test, 1, 2, 3, test.
We all set? Good morning, everybody. Can you hear me? Okay. Well, thank you for being here this morning. My name is Andy Cohen. I know a lot of familiar faces from previous times that I've been here visiting your park. For the new faces, glad to meet you this morning. I just want to encourage everybody to ask questions. I'm glad to. Don't worry about interrupting the flow or anything along those lines. I'm glad to answer questions all throughout the presentation. This morning, we're going to have a PowerPoint presentation. First, we're going to take up sunshine laws. Then we're going to roll into public records. Then I think we're going to take a break. And after the break, we're going to do ethics laws. To go with the PowerPoint for each particular section, I've prepared a little exam. It's graded on the honor system, or our teacher here might grade it, whichever. But don't worry too much about that. And with that, I'm ready to proceed unless anybody has any questions off the bat. All right, great. So our first topic this morning is the Sunshine Law. And first we have just a little cartoon, which is a good backdrop as to what the Sunshine Law is and how it came to be. The whole idea behind the Sunshine Law is to have open government. is public bodies like Holiday Park, which is, we all know, a little mini form of local government, a special district. The idea is to have district business done in the open. So no more of these, caricatures of back smoke-filled rooms where deals are being made. I recognize that it might not always be the most efficient way to proceed with your district business, and of course, I hear that a lot from my boards. But that is the idea behind it. Let me break for 1 second. One thing I forgot to say is just again for those who don't know me, we have offices in Lakewood Ranch and Venice. I represent a number of special districts. A glutton for this type of work for some reason. I've been with Holiday Park for a good many years now, and I appreciate the opportunity to always be here. I also represent Tripar as well as Trailer Estates. I know all three of you work together quite well to tackle a lot of these topics. So, okay, so what is the Sunshine Law? It comes from a constitutional and statutory right of the public to observe all discussions and deliberations taken by a public board. Where do we find it? We find it in the Florida Constitution, Article 1, Section 24B, as well as Florida Statutory Law, Section 286.011. The bottom corner there is a little picture of a manual called the Government in the Sunshine Manual. This is an excellent, excellent resource. It has a lot of great information in there about public records as well as the Sunshine Law. And if you're having trouble sleeping at night, I highly recommend it. So the Sunshine Law has 3 requirements. It seems complicated, and in a ways, maybe it is complicated, but it really comes down to 3 simple elements. 1, meetings of the public boards, as yourself, or commission must be open to the public. Reasonable notice of such meetings must be given, and minutes of the meeting must be taken. Those are the 3 requirements. Now we're going to go through and dissect those a little bit and try and flesh out what some of that means. So the first one, meetings of the public board or commission must be open to the public. First question is, what's a meeting? And then we can talk about, well, once we know what a meeting is, what does open to the public mean? Meetings are defined as all discussions and deliberations by 2 or more members of the same board, whether that meeting is formal or casual, relating to a topic that is pending before the board or that is foreseeable to come before the board for action. I would go one step further. I'm very conservative in the approach that I take with regards to the Sunshine Law. And we'll talk about a little later why that is, because if you screw up, it can cost you a lot of money. So I like to say that no 2 board members should discuss any district business outside of the Sunshine, outside of a duly scheduled public meeting. You never know. Well, I didn't think this was going to come up. So, the question about would foreseeably come up or something along those lines, it's just safer. Don't talk about it at all. Yes, sir. Good. I know. Yep. So those people that you meet with, first of all, the manager, well, let me back up. Is it a committee that was formed? So it's a finance committee, and that committee makes recommendations to the board. Then you have to meet in the Sunshine. You have to advertise your meetings. You are subject to these same rules as you are as a board member. So you should not be, for instance, emailing your fellow committee members outside of that meeting. And you have to advertise your meetings. And who were they? They were appointed by the board as I said, to make recommendations to the board. That is a committee that would need to meet in the Sunshine. You should allow the public at your meeting. Yes. Well, it'll be just like at your board meeting. You can limit, and we'll talk about this too, but you can limit public input. So you would have to take public comment at the beginning of your meeting, okay? If anybody wanted to offer any. And then they're done. And then they can sit and watch, but you would have the opportunity to conduct your committee meeting. No interrupting unless you wanted to let them. There will be no interrupting and such. But that committee that you just described to me has to meet in the sunshine. Now, if you wanted to sit down with Carmela and talk about finance issues, you're free to do that anytime. If you and Carmela wanted to sit down with a couple of residents who had some ideas about something, you'd be free to do that. But because you have a committee that's appointed, I'm repeating myself, but has appointed by the board, doing more than just fact finding. So you're making recommendations, which is what most committees do. I mean, you want them to do some good work for you, bring some recommendations back to the board. Then you have to meet in the sunshine. It's not horrible. It's not impossible. It just means advertising your meetings and being cognizant of these other issues that we're going to discuss, like not meeting outside the sunshine and going back and forth about things. I would suggest, and I would assume that Carmela is not a member of the committee, just the liaison to that committee. Okay, that is good. You should make them, which you already have, you should always make those type of positions a liaison. So that way, Don, you're free to meet with Carmela whenever you want and talk about finance issues. If she was a full-fledged member of your committee, you'd have a problem. Mm-hmm. Mm-hmm. Understood. No, I got, there's a couple hands here, I guess. Your new rules, right? what is so it's separate from the board. They do their own work. I understand the process, I think, where you make a determination, you the board, and then it goes to them to make second level determination, I'll call it. But if you're appointing, they're doing their work separate from the board, but if you're appointing the people to that committee and they're doing final action, I believe it would be safest to have them meet in the sunshine. Yes. So they need to advertise their meetings and they need to keep minutes, just like you would need to. Okay. The only people that have to have the 4 hours of Sunshine Public Records and Ethics training are the 9 district board trustees. Is it advisable for your other committee members? Absolutely. I mean, who wouldn't want to learn this great stuff? But the only required individuals are the ones that file the financial disclosure. So you 9 board of trustee members, because on your disclosure form, you're going to check the little box that said you had training. Oh, of course. Yes. Yes, they are still required to follow the law. You don't want to have them make a mistake that could subject the district to some sort of litigation or something along those lines. But they do not file financial disclosure form, which is where this requirement will show up. As I said, you're going to have to check the box that you've had your training. Yes. When the Enabling Act was revised. And that's absolutely good practice. And that's absolutely something that you as a board can require. You could say, hey, if you want to be on one of our committees, you got to come sit through Andy's discussion. That's something that you as a district can establish as part of your protocols for appointing people to the boards. Yes. And obviously, for all the reasons we've been discussing, it's a good idea for protection of the district. Sure. That's excellent. Okay. Sure. Yes. Okay. Well, here's the thing. Sure. Here's the thing is that you are required to advertise in the newspaper, okay? Nobody reads the paper anymore. I get it. I stopped getting the paper like 2 years ago. But paper is expensive. So, it can get pricey to place a meeting, an ad every week or whatever. So what you should be doing, and what I believe you are doing, is you establish a schedule. Like, let's just talk about the board right now. So the board will say, meets the second Tuesday at 10 a.m., okay? So then you just place one ad with the whole meeting schedule for the fiscal year. If you need to cancel a meeting, you can do that without any re-advertising. If for whatever reason you need a special meeting or something out of the sync, then you would need to advertise that one-off meeting. So what I would recommend is that each of your committees also establish a meeting schedule, again, the first Monday at 6 o'clock or whatever, and you can each year just place one ad. Now, as we said, nobody reads the paper, okay? So putting it on your server, putting it on the bulletin boards, sending out a mass email if you decide that that's prudent. Those are all great things, and that's where people will find out most likely about what's going on. But unfortunately, it does not meet the statutory requirement. So, all of my boards, they put it on the website. Like I said, if they have a bulletin board near the pool, they'll put it up there, etc., because that's where people are reading it. But there's still the requirement that you have to put it in newspaper, and that newspaper needs to be qualified to do legal advertising. A lot of them, it used to be the only game in town was like, the Herald Tribune or the Charlotte Sun or something like that. But a lot of papers have sprung up, like the Business Observer, that do it for a lot less money and have jumped through the hoops to meet those legal statutory requirements. There is another very, very complicated process of utilizing the website of the newspaper, and you have to follow all these requirements. And of 25 special districts that I represent, not one of them has elected to use it just because it's extremely burdensome and cumbersome. So everybody, the way that we accomplish it is what I said. You come up with a schedule, you place one ad, and then you advertise it to your community the best way you know how. Yes. Mm-hmm. Yes. Yes. 7 days ahead. You could do one. You really could. You could do one long one that says this is when the Board of Trustees is going to meet. This is when the XYZ committee is going to meet. This is when the Finance Committee is going to meet. Yes, they are. That's what sunshine means. Correct. Correct. Yes. Mm-hmm. The public needs to have an opportunity to provide their public comment. It can be done the way that I assume you do your trustees meeting, which is you'll have an agenda so the public knows what's going to be on the agenda. You'll have an opportunity for public comment at the beginning of the meeting. You can limit it, 3 minutes, let's say. Everyone has their opportunity to make their comments. And then when public comment is closed, the meeting happens. I tell people, think of it like a county commission meeting. People don't jump up in the middle of a county commission meeting and start, raising their hand and making comments. So that is the way that you conduct your meeting. Now, whoever is conducting the meeting, whether it's the chair or whomever, might decide, hey, this is a really important issue. It's a packed room. Some people might have some more questions. You can always choose to open it up for additional questions if you want, but you do not have to. You have a question in the back? Yes. Mm-hmm. No, you would list the exact dates. Yeah, and so you could do one long ad says Board of Trustees is meeting on May 6th, June 12th, and July 15th at 2 o'clock at such and such location. And the finance committee is meeting on April 4th and, May 17th at 2 o'clock at such and such location. Yes. Mhm. Okay. This whole side of the room is just monopolizing everything. Okay, thanks. Oh, okay. I thought everything was fixed anyway. Again, yes, under my advice, I would say just don't do it. Don't talk about district business with your fellow board members. You talk to other residents. You can still have friends if people want to be friends with you, He seems like a nice guy. Help me carry my stuff in. You can still have friends. You can still talk about pickleball. You can still talk about hockey. You talk about all sorts of non-district related business, but I would tell you to be careful to talk about district business outside of a duly scheduled meeting. Because like you just said, using your example, you're pitching around ideas and like decide, hey, it would be awesome if we built a, I don't know, one more pickleball court. Okay. And then it comes before the board and says, hey, we've got some extra funds in the budget. Do we want to build a pickleball court? Then all of a sudden, you've got an issue. Even when it could potentially come, 2 years from now. And if you and that same person are both board members, potential problem. So as I said, it's, still got to live your lives. And, we all make calculated decisions every day. Okay. But just keep in mind, Andy's voice in the back of your head. It's better not to discuss district business outside of a duly scheduled meeting. Right? Well, first of all, it'd be best for that one board member that was, the question was asked of to say, hey, let's do it another time. First of all, I'm playing pickleball, leave me alone. But, let's do it another time when 2 other board members aren't present. I'm glad to sit down and spend a few minutes with you. And the other thing is, which you bring a good point of, is that perceptions matter. Okay. I mean, even though you're sitting there, you're playing pickleball with 2 fellow board members and you're really not doing anything wrong. You're only talking about pickleball, about the weather, about the Lightning losing last night, things along those lines. Somebody's going to walk by and be like, I saw them and they were talking about the item that's on the agenda or whatever. So, again, you're still allowed to have friends. You want to play a pickleball game with your friends, go do it. But keep in mind that perceptions are out there. So, if you can, minimize those situations. But the other thing that we're going to talk about is that the big elephant in the room with violations of sunshine and public records is that, yes, and we'll get to this, yes, there's criminal violations, yes, there's fines. But if you get sued and the plaintiff is successful and they recover, they will be entitled to recover their attorney's fees. And there are cases out there, including one from the city of Venice, just more than a few years ago now, but there was $2 million in attorney's fees involved. And you do not want to be the one that costs your district hundreds of thousands or more of attorney's fees. So this is important stuff. And it's important, it's important stuff, period. But that. Absolutely. Absolutely. I do. I'm an example of that. Yes. Okay. So, all right, and again, keep asking questions. I'm glad to answer them if I can. So we had that first requirement of the Sunshine Law, which was that meetings of public boards must be open to the public. So what is a meeting? as we said, it's 2 or more. So those of you who come from an HOA background, it's a little bit different law. It's a quorum. So if you got a 5-member board, 2 people can get together, 3 can't. But in our public government realm, no more than 1. So 2 or more, out of the question. Yes, you can talk to yourself. 2 or more members of the same board. So you're free to talk to a board member from Trailer Estates or from Tripar or staff, but it's you and a fellow board member where you get into trouble. And you shouldn't be talking about any district business. And that is more than just the classic that we're thinking of, you know, I pick up the phone and call a fellow board member. Or I'm talking to him on the pickleball court. The thing that does trip people up is emails, texts. First of all, you shouldn't be texting anyway, and I'll talk about that in a minute. But emails, you should always be using your, quote, district email address, because for public records issues, you want to be able to have Carmela and the team be able to pull down those records if you ever get a public records request. So always use your district email address. If somebody, a friend, a neighbor, whatever, emails you, they have your personal email address, forward it to your district email address and respond from there so that you have a record of it. So that is a meeting, though. When you have that interaction, it's the exchange of ideas that equals the meeting. Sure. No. So you sit on the board with Sean, okay? Huh? Example. I know you would never do that, but you know. If you sit on a board with Sean and Bob is on a committee and he's not on your board, you're free to talk to a committee member. It's people of the same board because they are the ones that are going to be meeting together and making decisions together. So you could talk to a committee member. You could talk to staff individually. 2 of you couldn't, of the same board, couldn't go in and talk to them. But it's those people on the same decision-making body where you have the problem. Individually, yes. You can't bring a couple of your committee members with you. Correct, because if you have 2 committee members together, you've got a problem. But 1 committee member can speak to a trustee, absolutely. Yep. And it's not up there, but just one other aside is it's not an election year, but keep in mind that when we do have elections, if you are an elected board member, which means that you've already won your election, you're going to be joining the board of trustees, let's say, or you're running unopposed, so you're basically elected, you are treated as a member of that board. So if you are elected to the board of trustees, don't be speaking with the people that you are going to be serving with. A lot of times people will say, well, how do I get up to speed on what I got myself into here? You can speak with whomever is exiting the board, say the seat you're taking, because you're never going to be serving together. Yes. If they are leaving the board, not if they're staying on the board, you're still not allowed to speak with them. If you want to get up to speed on compounds or whatever it may have been, then you should speak with someone else that might have assisted them, or perhaps Carmela has the information or something like that. But that, let me say one thing, is that you can't ever use Carmela or anybody as a go-between. So you can't say, two board of trustees, Don and Sean can't say, Don can't say to Carmela, hey, tell Sean I think X. Sean say to Carmela, well, tell Don he's full of it, I think Y. You know, this is a hard room. So you can't use anyone as a go-between to try and violate the Sunshine Law. Next slide. Thanks. Meetings can occur anywhere. They can occur at Publix. They can occur playing tennis, pickleball, golf, lunch, dinner parties, parks, on the phone, text, email, electronically, etc. That's what I was getting to before. It's the exchange of ideas. Let me say, we just glossed over it, but let me say texting. You heard me say don't text, don't do it. Unless you have, which I don't believe you do, district issued cell phones, nobody is capturing those texts. So if you get a public records request that says you're not violating anything, let's say Sean is texting with Carmela about district business, and then somebody says, I want to see all Sean's texts related to the landscaping vendor from the last month, okay? You're now the records custodian. You need to produce those. So if it was an email and they asked for your email, well, the team has those and can produce them. So I say do not text about district business. Only use your email address for communication. Don't do social media. Nextdoor, Facebook, same problem. First of all, you can get into a sunshine problem if you say something and another board member then comments on it and you engage in this exchange of ideas. That could potentially be about district business. That could potentially be a sunshine violation. But you also have the public records issue of who's printing out these communications and keeping them. So don't do social media, don't do text for your district business. Use your email address. Yes, sir. If you're subject to the sunshine, which sounds like the committee you're talking about is, you have the problem that I said, which is just like the board. You should not be exchanging ideas. You could send information out, and I'm going to get to that in a little bit. But you could say, hey, here is a bunch of information for our discussion at the meeting on Monday. Do not reply. That you can do. But you cannot say, here's this, what do you think about it, etc. That's a sunshine violation. And using your email address, your district email address, is great because it will help with public records issues, but it doesn't cure a sunshine violation. Okay. So what else is a potential meeting? We said telephone conversations between board members, any communications, postings, or debates relating to government business, text messages, communications relayed through an individual acting as a conduit, and a response to board member views on a particular actions. We covered most of those, but the last bullet point is something that we just talked about, which is I prefer that you don't communicate at all about district business, but I get it. I recognize that sometimes you need to get information out there in order to be the most efficient at your meeting. So your finance committee, Don, like we were just saying, if you say, hey, our meeting's tomorrow, I've been through the budget, these are the 6 items where I see a problem that we need to discuss on Monday, you can distribute that to your other finance committee members. I would put in big capital letters, please do not reply all. The problem is that even if someone writes back and says, thanks, Don, see you Monday, you got a problem. So it's best not to do it at all, but I recognize that sometimes it's just necessary. And when it is, just try to be cognizant of that and say, please do not reply. And that's sort of what is referred to here as these position statements and papers. General rule is that a single one-way communication from one member of a collegial body to the rest of the body on a matter coming before the board does not violate the Sunshine Law, but subsequent commentary or interaction between members relating to the initial communication can constitute a meeting or a discussion. So here comes the recommendation, which is refrain from doing it. Channel your discussion to the public meeting, but guess what? I understand that it's necessary sometimes. Next slide. There's the reply all. So that's when you get in trouble. So we talked about what a meeting is, and we talked about how it can take place in all sorts of different forums. What does open to the public mean? And we've gotten some questions on that already this morning. So that meeting needs to be open to the public. Open to the public is what you would initially think, that the facilities have to be accessible, the doors unlocked, things along those lines. Non-discriminatory. Your room right here, excellent. You know, everybody, I think, feels welcome from the park. You don't lock the door, things along those lines. Some of your committees might be meeting in some of your smaller rooms. That's fine too. You know, you're at the central gathering place for your community. No inaudible discussions. This is something that you'll see at all levels of government. Bless you. Is that you need, talking about perception again, you need to be careful. So let's say this room's set up for a board of trustees meeting. You've got all your trustees sitting up here. The meeting hasn't started yet. Sean's got another trustee sitting next to him. You lean over and you're talking about whatever, as I said, the weather, okay? Got a whole room full of people here, and they're going to be like, they were talking about agenda item number 1, and they've already got their mind made up on what it's going to be, et cetera, et cetera. So you need to be careful of that. There can be no inaudible discussions. The public needs to have a meaningful opportunity to provide input. Yes? Well, if they're talking to their spouse about what the grocery list is, it's fine, obviously. But if they're talking to a fellow board member saying, hey, what are you going to vote on agenda item 3? I think it's, you know, a stupid idea or whatever. Yeah, that's a violation. And then the next issue is the one we keep talking about. Even though I was just texting my wife about what I was going to pick up at Publix on the way home, someone's going to be like, well, I saw Sean texting at the same time, and even though he might have been texting about scheduling the pickleball meeting in the morning, you know, so be cognizant of those types of things. No confidential votes. This comes up usually when or most prevalent with me, when when board members are appointing someone to fill someone else's term. So someone has to resign for whatever reason, and it's up to the board to fill that seat for the remainder of the term. Typically, I don't know how you do it, but typically you have, you know, put it out to the community. You'll have some candidates come in, tell us a little bit about yourself, and, you know, you'll make an appointment. A lot of times they'll be like, well, they're all great, and 3 of them are my friends, and, you know, I don't really want to vote against John, et cetera. So, can you do a confidential vote? No. Some boards, I really don't think it makes a difference, but some boards do a ballot, but the ballot can't be secret. So you write down the name on it, and then whomever is tallying up the ballots, let's say it's Carmela, has to read off the ballot in the meeting, Sean voted for Frank, and such voted for John. And so maybe it makes you feel a little better because you can, you know, hide your face or whatever, but it all has to be out in the open. No informal, unofficial votes, and no polling. So what Carmela can't do is go, hey, there's an item on the agenda for fixing the pool at the meeting on Tuesday. What are your thoughts? Or do you think we need to put this on the agenda or something along those lines? You can't poll the board members and get sort of a consensus outside of the meeting. Public has a right to view meetings and hear all discussions. So what about meetings with staff? We talked about that. As long as it's one board member can always meet with staff. So the chair can go and meet with Carmela, go over things for the agenda, how they're going to conduct the meeting, what's the latest on the pool vendor, has he submitted us a contract yet, whatever. The only time that you wouldn't be able to do that is if staff takes on like a more pivotal, I'll call it, role. So let's say, you don't usually do this here, but if you're having an RFP for something and you're appointed 3 members of your staff to be a committee that's going to make a recommendation to the board about those RFP proposals, bids that they received. Well, now they've taken on sort of a different realm. They're not staff anymore. They're this committee that's making a recommendation to you. Talking about staff, what about meetings with the attorney? Well, the board, any individual member can meet with the attorney anytime. The board cannot meet with the attorney outside the sunshine unless you have pending litigation. And that's called a shade meeting. And when I say pending, it means that the case has been filed, there is a case number assigned to it. So a lot of times, rightfully so, let's say you're unlucky enough to get sued. Someone trips and falls in the pool and they're suing you. The board might say, hey, we'd like to discuss with you, Andy, that, we think we can resolve it for $100. I think that'd be a great idea. We want to talk about settlement with you. Can't do it outside the sunshine law. Then if they sue you, maybe I forgot to mention, they're threatening to sue you. Then if they sue you, then you can meet with the attorney, but it's still really, really limited. You have to have a special ad place that says who's going to be there. You have to start in a public meeting, go into this closed session, and a court reporter needs to be present the entire time. And then at the end of the litigation, when the litigation is over and done with, then the court reporter's transcript becomes public. So it is a possibility, and you can only talk about settlement negotiations and litigations related to the lawsuit during that shade meeting. All right, so open to the public, we know means that the room has to be unlocked. It needs to be a place that's inviting, it doesn't discriminate. Open to the public also means the public's right to speak. We already answered a couple questions on this. So in 2013, the legislature passed Statute 286-0114, which requires that the public be provided with a reasonable opportunity to be heard. I think we're one slide back. Back the other way. Nope, that's it. You got it. Thank you. Which requires that the public be provided with a reasonable opportunity to be heard on a matter before the board takes official action. So that's why I always tell my boards, put your public comment at the beginning of the meeting. So that way you've got your agenda, the public sees you've got item 2 on the agenda is hiring a new landscape vendor. They have their opportunity to say, I think that they're doing great, I think they're doing awful, whatever, to provide their input. Now, what if your agenda changes? You can change your agenda. What if during the discussion you go off on some, tangent and you're now all of a sudden about to vote on something that wasn't on the agenda? You can do it, but you have to stop and pause and provide the public an opportunity. So if you're somehow getting to an item that wasn't on the agenda and you're about to vote on it, you have to stop and go, members of the public, now's your opportunity. Do you have any input on this? You take whatever their comments are, and then you can vote. So you don't have to be rigidly stuck to your agenda. You just have to make sure that everybody has an opportunity to address things that you are going to be voting on. But it does not mean that the right to speak is unfettered. So you can put time limits on it. You can have public comment at the beginning. You could say we're limited to 3 minutes. And you don't have to put up with discourteous and, outbursts and things along those lines. If someone is being discourteous or they're screaming and yelling and cussing, you can remove them from the meeting. In fact, I would say you should recess. You could give them a warning. They cut that out or we're going to stop you. And if they don't stop, you stop the meeting and you have them removed. As I said, you can put limits on 3 minutes. You can hold up a time clock and, if they're like 2 words to go when the clock goes off, I usually say let them finish. But you know, you don't have to let them ramble on for 20 minutes or something like that. Yes. Yes. Okay. Okay. And that's all that's on the agenda. So I do think that it is allowable to limit your. You don't have to do comments at the end, by the way. And if you don't, then your comments at the beginning should be on everything. But if you're doing it that way, and a lot of boards do, if you're doing it that way, then yes, I think it's okay to have the ones at the beginning just be on agenda items. And if it's a finding committee, it may be just those cases that are there. Yes. Bless you. Well, it depends on how your agenda is structured. I mean, if they have information about that particular case, then they should be able to add that information. But if it's just a exchange, in other words, it's set up as just a hearing between the alleged violator and the committee, then that's a different issue. Correct. Correct. Yes. No public comment. No outside public comment on that one. Yes. 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 Mhm. You ask them to leave, okay? 9 times out of 10 they'll be pissed off, but they'll do it, okay? If they will not leave, if like forget it, I'm not leaving, you know, come remove me, call the police. The police will trespass somebody from a meeting. Yes. Yes. And they will do it. You know, they don't like to normally get involved in civil matters, which I understand. They're doing very important things out there, which may not be precedence over the holiday park meeting, but they will come, and they do have the right to remove them from a meeting, even though it's a public meeting. A lot of times people say, it's a public meeting, I can be here, I can do what I want. No, you can't scream fire in a movie theater, and you can't interrupt your board's business. So, yes, 9 times out of 10, they will not be happy, but they will leave. But if they don't, you call the police. You're absolutely right. Don't get involved with putting them in a headlock or something like that. So, okay, first requirement, meetings of the public boards must be open to the public. We killed that. Second requirement, reasonable notice of such meetings must be given. Well, for a lot of groups, reasonable is sort of a squishy subject in the law, but we happen to have a statute directly on point, 189.015, which requires special districts provide at least 7 days notice before a meeting, and it needs to be in the newspaper, like we talked about. Notice can be reduced for a bona fide emergency. I will tell you that. And this, obviously, in the past few years has come up with hurricanes and storms and things along those lines. If you have to meet on an emergency basis, you just, quote, do your best. I mean, you try to, you're not going to be able to get it in the paper quick enough, okay? In fact, what I'll tell you is to put it in the paper afterward, even though it's already occurred. but do your best, meaning use those other avenues you have available to you. Put it on your website, put it on the bulletin board. We're having an emergency meeting tomorrow morning at 8 a.m. If you use all of those things that are available to you, in other words, you're making an attempt, you're not trying to have a secret meeting, you're going to be fine. And then I would also recommend that at your next regular meeting, whenever that is, you simply ratify any action that took place at that emergency meeting. That will protect you. Not 100%, nothing's 100%, but that will be a good guide. Yes, sir. If you cancel a meeting, you do not need to put it in the newspaper. So again, just use your normal, your typical community type communication that you have. You send out an email, you do put it on your website. Maybe if the meeting was supposed to be on Tuesday at 2 o'clock in this room, you put a sign on the door, things along those lines just to let people know, but you are not required to advertise it. As we talked about, reasonable notice does not mean that you have to stick to your agenda. You need to have an agenda. It needs to be published for the meeting so that people have an opportunity to decide if they want to come or not come, or address a topic or not address a topic. But you can add things to the agenda at the beginning, and you can add things on the fly as long as the public has that opportunity to address those items. Okay, meetings, reasonable notice. Third requirement, minutes. Minutes must be taken. We've talked about this previous times I've been here. There are no Disney magical minutes. There's no template that, that's in the statute that you have to follow. It's just basically a brief summary of what happened. I usually tell my boards, try and capture the things you would think about. Who was there? What motions were made? Who made them? Who seconded them? Maybe a little bit of text about, discussion. The board had a discussion on the landscape vendor. John made a motion. Don seconded it to terminate them. Whatever. Something along those lines. You do not have to tape your meetings. I don't know if you do or if you don't. But if you do, that is a public record. So you have to retain that tape. Other people, this is a public meeting, so other people are allowed to record your meetings. I get that question sometimes. A resident will walk in, put their phone like this, and start recording. And you're like, what are you doing? They have the right to do that. It is a public meeting. And you do not need to worry about keeping that record because it's not a record that you created. I wish there was a better answer for this, but there are different requirements for different records. The way the state of Florida works, there is a laundry list, and you basically have to look at that list to make your decision. So certain things like bond documents for your financing are required literally to be kept forever. Other things are transitory and can be disposed of within a number of years. And so you literally have to take a look at the list, see meeting tapes, how long do I have to keep those? And most things hover around 5 to 7 year window. But I will tell you that there is a published list and you have to look at that before disposing of things. But you are free to dispose of things that you already have. So let's say that you are a board member, you get an agenda package, you print it out, you bring it with you to the meeting. Because Carmela and team prepared that package and already has it, you're free to chuck it when you leave. If you have something in there that you created, we'll talk about this, but if you created something for that meeting and you used it and announced it in the meeting, so it became a public record, that would be something that you would have to keep, or I would just recommend you hand it to staff and say, hey, append this to the records from this meeting so that we're sure we have a copy of it. Yes. It is the district, but you individually as board members do have a responsibility. As I said, if it's something that the office, we'll call it, wouldn't otherwise have. So if Sean created a document, read from it at the meeting so that everybody who was there heard it, that document is a public record. Sean would have to keep hold of it. And then when you leave the board 20 years from now, you would give that record to the office and say, hey, you guys don't have a copy of this. That day, tear it up. Absolutely. Absolutely. Yes. The office is, I'm using the term broadly, but the office is the public records custodian for the district's records. So if somebody said, in a couple of examples I've said, you get a public records request for all emails related to, we're picking on the landscaping, for the landscape vendor over the last 6 months, the office team would be the public records custodian to assemble those documents. And if you individual board members have been using your correct email address, they should already have it. And you, because of all the money you get paid, do not get paid enough to be your own public records custodian and have to comb through all your emails and assemble all this information, etc. Yes. It is readily available. It's through the state, and it's called, like, I'm not getting it exactly right, but it's like the Department of Library Services or something along those lines. I just heard they have a copy in the office. So all right, so the minutes, like we said, they're not magical. They should reflect board determinations, motions, and votes. Must be promptly recorded and open to the public for inspection, including drafts. Yes. No, I think it's fine to only post the regular. Right, but if somebody says, I would like a copy of the draft minutes, okay? They are entitled to receive a copy, and you can say all over it 10 different disclaimers. These are draft, these aren't finalized, the board might have some changes, but you can't go, oh, well, they're not done yet. If they're done, if they're on, they've been done, yes, they can get them. But no, I wouldn't start putting drafts on your website. It just creates confusion. And they do not need to be verbatim. Sometimes boards do want to do verbatim minutes. Actually, I think that leads to more problems because then it's like, it takes a lot more time, that's for sure. And then everybody's like, no, I said the word the instead of then, and it's difficult. Okay, so what are the penalties if I screw up? What are the penalties for the Sunshine Law? Criminal penalties, second-degree misdemeanor. You could potentially be all the way in handcuffs, although it's pretty rare. They're non-criminal infractions, fine. Both of those are pursued by the state attorney's office. Any action could be void. And then the last bullet point is the big one that I talked about before, which is civil action. If somebody sues you for a sunshine violation, they are entitled, if they're successful, they are entitled to their attorney's fees. It's not even a question that the court has to decide. That says shall. They shall recover their attorney's fees. So, fortunately or unfortunately, our area is a hotbed for this. Manatee County, Charlotte County, Sarasota County, City of Northport. That's where all of the cases come out of. I mean, people might live in Miami and they're reading about cases from the city of Northport. That's just the way it is. There's a small group that is very active across the entire state, and they live right here. Um, no. So, so we need to be careful of that for obvious reasons. And also, if it is something that you have done, I mean, you have insurance, okay? You have certain instances where the district is going to indemnify you and things along those lines. But keep in mind that if you are doing something outside of your fiduciary duty, let's say that Andy told you don't meet with your fellow board members and discuss, district business, but you're like, doesn't know what the heck he's talking about. And you do it 6 different times, okay? Purposeful. You're just like, I don't care about this sunshine law. Forget it, And then the district gets sued. You might have to pay personally because you're acting outside your fiduciary duty. The insurance company might go, this guy was warned 6 times. We're not going to pay for it. So you need to be cognizant of those things. All right. Before we do public records, I have a little test here. Should have it in front of you. Looks like this. So, first question. Dolly and Goldie are members of the same district board. The board has set up a committee to make recommendations as to events the district may wish to implement at its clubhouse, including an event related to Botox and plastic surgery. Does the committee have to meet in the sunshine? The answer is yes. So again, it's not hard. It's the things we talked about. Meetings open to the public, meaning that they're advertised, reasonable notice, and minutes taken. Not rocket science. We can do it. We know how to do it. It should be done. Number 2, Stormy and her friend that goes by the nickname H2O are both members of a district stormwater infrastructure committee. While shopping at the farmer's market, they bump into each other and strike up a conversation about groovy hippie names. They can discuss the following other topics without violating the Sunshine Law. The answer is C. So even though it may not be true, they can talk about sports or the stellar performance of the New York Jets. And again, a meeting is 2 or more people from the same board discussing district business. Number 3, the district board has business to discuss and they do not expect a crowd, so they assemble at one of the members' homes. 7 days notice is provided in the paper and minutes are kept. There has been no sunshine violation. The answer is false. So even though you might, leave your front door open, put a big sign out on your lawn, everybody welcome, please come in. There's an attorney general opinion out there that says it sort of has a chilling effect. People might feel like, I don't want to go to Sean's house. I don't know what happens there, etc. So that's, again, you have your meetings, I know, here. Yes. Mm-hmm. Right. It's, define clear violation. I wouldn't recommend it, okay? Is it like automatic, you were in the house, boom, you're violated, a little bit of a gray area, but if at all possible, I would recommend not doing that. So find space here. I know you have another smaller clubhouse, find space there. Some of my boards don't have any clubhouse. They meet at the library down the street, It is a public building, and as long as it's noticed, it may not be the most convenient, but I don't recommend meeting in a home. Chase and Fargo are members of the district board, and they have an issue related to obtaining a reserve study. They know they are not allowed to physically meet with one another outside of the sunshine to discuss district business. To avoid any appearance of impropriety, they avoid sitting down together at the district pool to discuss the issue. Instead, Chase calls Fargo on the phone and they discuss the best options for the reserve study. There's been no sunshine violation. The answer, false. Right. Because they still had, quote, a meeting, whether informal or informal. Number 5, Jerry, George, Kramer, and Elaine all serve together on the district board. Jerry heard a rumor that there will be a lot of disgruntled residents at the next district meeting protesting the recent recommendations adopted by the board that the serving of coffee and donuts at the meeting should be banned. Elaine wants to make sure that her fellow board members are aware of the rumors about the upcoming protests in case an emergency meeting needs to be called. She sends a group text to her board members to let them know. Kramer replies all to the group text that these protest actions are ridiculous and the protesters should be publicly ridiculed. Jerry replies to Elaine with a joke and that he agrees with the protesters and reminds her that he voted against banning coffee. George does not respond. Did a sunshine violation occur? Answer is B. Yes. So why is it not A? We printed all the text messages. Well, might be okay public records wise, but it's still a sunshine violation. Not B, because texting is the communication that presents the problem. And even though George intends to bring it up later, you still have that violation. So you can't cure it, per se, just by saying, well, we were going to bring it up anyway. Last one, violation of the Sunshine Law is subject to the following. The answer is E, all of the above. That case I talked about in the city of Venice, the plaintiff was awarded close to $780,000 in attorney's fees. By the time the city paid the plaintiff and took care of their own attorney's fees, they incurred almost $2 million. So that would be bad. So that is sunshine. Any questions before we go to public records, or do we want to take a quick break? You have some. We'll take a 5-minute break. I'll answer the questions when we come back. How's that? I know. You gotta move over here.
I feel like I'm working at a hospital.
Have lunch. Thank you. Whatever you. Well, I'll eat some. All right, while people are. I'll go- Right.
Now,
Or we could do public. We could probably run through public records pretty quick and then eat. And ethics, whatever you guys want.
on him.
Yeah, I'll eat something quick and then we'll get.